Imagine this common scenario, right? You bought a franchise thinking that you'd be your own boss, but now you're facing a legal threat from the franchisor and they got deeper pockets than you. Maybe they're claiming that you violated the operations manual. Maybe they're alleging that you underreported royalties. Maybe they're trying to terminate your agreement for whatever reason. And suddenly you realize that you're in a legal fight that you can't win. So today, I'm gonna break down the 3 most common legal battles between franchisors and franchisees and how to avoid them before they destroy your business. I'm Karam, the 20-year battle-tested lawyer and entrepreneur. I've represented franchisees in legal disputes, and here's what I've learned. The franchise agreement is written to protect them, not you, and I've said this over and over, so by the time you're in a legal battle, you've already lost. So today, I'm gonna show you the 3 most common legal fights that destroy franchisees so you can avoid ever having those fights, and exactly what you need to do to avoid them before you sign that contract. So before we dive into the 3 legal battles, you need to understand something extremely important. Franchise litigation is almost one-sided. And here's what I mean. The franchisor has really deep pockets, like I told you. They got deep pockets to fund years of litigation. They have in-house legal teams or retained law firms on retainer. They have experience litigating against franchisees. They've done this before. The agreement's written in their favor. They have standardized legal strategies and contract language designed to win already embedded in their agreements. And the franchisee has really limited capital, right? Most of it's already been invested in the franchise, and most of them don't have lawyers. There's no legal team. They have to hire an attorney and pay hourly. It's gonna cost them a lot of money. And they have no experience with franchise litigation. And the contract, they didn't write the contract. It's not in favor of them, and they really can't change it. So it's a really lopsided type of arrangement. So if the franchisee is right, the cost of fighting can even destroy them financially, even if they're right. So most franchisees settle, not because they're wrong, but because they can't afford to fight that fight. And this is why prevention is everything. And like I said, you always lose in court no matter what. So you need to avoid these legal battles before they start. That's the whole point of this, because once you're in court, you've already lost, and that's why I've become a mentor. So let's jump in and talk about the 3 kinds of lawsuits that happen. Number 1 is the breach of operating requirements. This is called non-compliance, basically. This is the most common legal dispute in franchising. So what happens? The franchisor claims that you violated the franchise agreement by not following the operations manual or the marketing guidelines or the system requirements. There's all sorts of paperwork, and it's so easy not to follow things. So let's say, for example, you ran an unapproved promotion, or you changed your store hours without permission, or you used a different vendor than the one required, or you didn't attend a mandatory training, or you did something outside their SOPs, you modified the menu or the product offering. The franchisor sends you a notice of default, and if you don't fix it, they threaten termination, or they sue you for breach of contract, and they can take back their brand, right, and kick you out. So why this happens, right, it's because most franchisees don't realize how strict the compliance requirements are. The franchise agreement gives the franchisor the right to control almost every aspect of your operations. You don't have the control you really think you did. And here's the scary part. The operations manual can be changed unilaterally by the franchisor almost at any time, and you have to comply with it. So the rules you agree to when you signed may not be the same rules that you're operating under now. And the franchisor has tremendous leverage, right? If you breach, the franchisor can terminate your franchise agreement, and that's horrible. And then they can sue you for damages. They can refuse to renew your agreement, take back their brand. They can block you from selling or transferring the franchise. They can do so many things for you. It's extremely suffocating agreement. So how do you avoid this? Step 1, you read the operations manual before you sign it, right? A lot of people don't do that. Don't just read the franchise agreement. Ask to see the operations manual. Understand exactly what's required of you and whether you can realistically comply. Now, step 2 is document everything. The franchisor tells you to do something that violates the agreement or it's outside the manual. Get it in writing. Protect yourself, because if you need to deviate from the manual for a legitimate business reason, request written approval first. Make sure it's written. Step 3, respond to every notice of default immediately. If the franchisor sends you a notice of default, don't ignore it. Respond in writing. Cure the default if you can, or explain why you're not in breach. When you ignore it, it gives them grounds to terminate. And the bottom line is they can move forward quickly against you. Compliance disputes are the most common and the most avoidable. Know the rules, follow them or negotiate changes before you sign, or don't get involved is what I say. Here's legal battle number 2, royalty disputes and underreporting. This is where things can get really ugly and expensive. This is when the franchisor alleges that you underreported your gross sales and therefore underpaid your royalties. They conduct an audit, they find discrepancies, and they demand, or what? Back payment of royalties, interest and penalties, payment for the cost of the audit, and that gets expensive. Sometimes they'll threaten termination. And why does this happen? It's because royalties are typically calculated as a percentage of gross sales, not profit. But gross sales can be ambiguous, right? Does that include sales tax, tips, refunds, online sales, catering, or delivery? If you and the franchisor have different interpretations, they'll claim that you're underreporting, and the franchisor knows every trick of the trade. The franchisor's leverage is that most of their franchise agreements include an audit clause that allows the franchisor to inspect your books at any time, and guess what? It's going to be probably at your cost. If they find a discrepancy of more than 2 to 5%, depending on the agreement, you have to pay for the audit, like I said, even if it was unintentional. So an audit can cost $10,000 to $50,000. And if the franchisor finds that you owe back royalties, they'll add interest, penalties, and audit costs on top. Suddenly a $5,000 underreporting issue becomes a $30,000 liability, and you don't want to go anywhere near this. So how do we avoid it? Step 1 is understand your gross sales, right? As defined in your agreement. Read the franchise agreement carefully. Look for the definition of gross sales, because that's what governs. Ask the franchisor, what exactly is included in the gross sales? Can you give me examples of what counts and what doesn't? Get it clear, get it in writing, please. Step 2, use clean accounting systems. You have to, because they control your business. Don't mix personal and business finances. The franchisor will use it against you. Use the POS systems that accurately track every transaction. You're required to keep detailed records of sales, refunds, and expenses. Now, step 3 is pay royalties accurately and on time. So if you're unsure whether something counts as gross sales, ask the franchisor before you report. Don't ever guess, and don't try to save money by underreporting. That could come back to really haunt you. It's not worth the risk. Now, step 4, if you're audited, hire a franchise attorney immediately, and that's if they're reasonable. You can reach out to me, don't worry about it. Don't try to handle the audit alone. Now, franchise attorney, they can do a bunch of things. They can review the audit findings, they can challenge inaccuracies, they can negotiate penalties, they can protect your rights during the process. But I'll tell you this, and the honest bottom line is you're at a disadvantage. Franchisors are in a position of power. Royalty disputes are expensive and stressful. Accurate reporting, clean books are your best defense, because they are sophisticated and they got deep pockets. Now, legal battle number 3 is termination and rescission battles. Like, this is the nuclear option, and it's often the end of the franchisee's business, and I've seen this happen over and over. So here's what happens. The franchisor terminates you, right? That's scenario number 1. The franchisor claims that you breached the agreement for non-compliance, you're underreporting, whatever it may be, you're not following the operations manual, they terminate your franchise. So you're gonna lose the right to use the brand, the right to operate, your investment, your income, and you lose that tomorrow. Like, imagine that. Here's the second scenario. You want out of the business. You realize that the franchise isn't profitable. Now you wanna close or sell, but the franchise agreement has a required clause that makes you keep the business operating. There's no refund clause. There's transfer restrictions. You can't sell without approval. There's non-compete clauses. You can't open a competing business. You're really stuck, and it's horrible to be there. De-identification requirements, that means you have to remove all branding. So you're really trapped. Now, why is this the worst case scenario? And this is where you never want to be, because termination battles are expensive. It's litigation, they're emotional. It almost always ends up ending badly for the franchisee. Even if you win in court, you spent years and hundreds of thousands of dollars fighting, you're not operating your business, and the franchisor's got deeper pockets, like I keep saying. So they got leverage. That agreement is written to give the franchisor maximum control over termination. So you need to understand that from the get-go. They can terminate for breach, even minor violations. And it's horrible, but they can, and judges will side by them. They can block you from selling. They can take away the brand. They can enforce non-compete clauses that prevent you from starting a similar business. So it could get really suffocating, right? So you need to avoid all of this, and that's the key. So step 1 is understand the termination provision before you sign, and if you're hesitant, don't sign. Read the franchise agreement carefully. I can't tell you how many people don't read it. Like, look for what qualifies as good cause for termination, right? How much notice notice do you get before termination? What is good cause? Do a little research. Do you have the right to cure a default? What happens if the franchisor doesn't renew your agreement? Like, you got to understand all this stuff. Step 2, understand your renewal rights. Renewal is very important, right? Most franchise agreements are for 10 years, but the renewal is not automatic. And at the end of the 10 years, they got a lot of leverage on you now. So you got to ask yourself, do I have the right to renew, or is this just at the franchisor's discretion? You never want to be at their sole discretion. What conditions must I meet to renew? And if renewal is discretionary, you could operate profitably for like 10 years, and then you lose everything because the franchisor decides not to renew. You really have to look ahead years. Business operates for years. Step 3 is understanding transfer and exit options. This is what I mean. If you want to sell the franchise, what's the approval process? How does that go down? Can the franchisor block the sale? You got to really understand that, and under what circumstances. What are my obligations if I want to close down the business? What about step 4? Negotiate anything before you sign. So if the termination provisions are too one-sided, you got to try to negotiate and get yourself a lawyer to do that. You need longer cure periods. You need clearer definitions of good cause. You need stronger renewal rights, more flexibility in transfers. Most franchisors won't negotiate, but it's worth trying and it's worth asking. Step 5, if you're facing termination, get a franchise attorney immediately. Don't wait. Don't try to handle it yourself. Every contract has deadlines. Franchise attorney, they can really help review the franchisor's claims and try to negotiate something. Determine if that termination is lawful, and they can most importantly try to negotiate a settlement and protect your rights during the process, because at the end of the day, it is a one-sided relationship. And the franchisors usually have a legal team, and termination is the worst case scenario. So you really have to understand your exit options. And getting involved in a franchise is a scary thing, and it's dangerous. So you got to remember the 3 most common legal battles. Number 1, the breach of operating requirements. Then there's termination battles. And then there's underreporting and royalties and all that good stuff. But in all these 3 cases, remember this: the franchisor has the money, power, leverage. Your only defense is really prevention. And that's the key. Understanding the franchise agreement, understanding what it's like to be a franchisee, understanding that you don't have all the control you would have as an entrepreneur starting out their business. You're buying an existing brand, and you have to really understand that what position of power you're in. And that's really difficult. And that's also why I created the Legally Bulletproof Academy and the only business defense system for entrepreneurs, because I recognized after 20 years of law and business, that entrepreneurs lose not because of a lack of sales or marketing information and courses and coaches and all that stuff. It's because they didn't understand the legal mistakes, the risk, and enemies that take down their business. So that's why I created a risk report and business defense plan. It's a $7,500 mastermind that I do with clients one-on-one, but for you, it's free. It's there for you to help understand what risks and threats face your business. All you have to do is answer some questions about your business, and this report will be generated for you based on my AI proprietary system, and you will get a breakdown of exactly the vulnerabilities you may have in your IP, your contracts, your business structure, and what steps you need to take to fix it. Because this is all about getting yourself legally bulletproof. So if you like this video, smash the like button, subscribe to the channel, get your free risk report, click below. I'm Karam, the battle-tested lawyer. It's all about getting you legally bulletproof.